Thank you so much, Dean. Can you hear me? I hope my microphone's on. It's great to be in Toledo. I've been having a wonderful time meeting so many faculty members and students, and it's just, I'm so excited to be here. This is a topic I've spent a great deal of my life over the last 10 years studying, and I started a few years ago doing some empirical research, so I hope you enjoy my talk. So my daughter, who has no interest in the law, she's an artist, and she once told me, she said, "Daddy, I hope you realize I have no interest in what you do." And I started laughing and said, well, that's great. And she does. She has no interest. She's never been to a trial of mine. But she is interested in implicit bias, and so she sent me a slide. And she said, "Daddy, if you could only show the audience that you speak to one slide, I have the perfect slide for you." So here's what she sent me. And the punchline is, which one was convicted of a federal felony and served time in a federal prison? And it's not Snoop Dogg. So for some of you who sat through the noon presentation, I've mixed it up a little bit. Some of the information is the same, but I've added and subtracted some things. But we need a definition of implicit bias, so this is a pretty standard one. It refers to the automatic instant association of stereotypes or attitudes towards particular groups without our conscious awareness. So here's the thing that's really hard. It was the hardest thing for me to wrap my mind around. How could somebody like myself, who's taken a number of explicit measures of bias, and I show no bias, have such strong implicit biases? And that's really hard for people to accept. So I'm going to try and explain to you why that's the case. And part of it deals with stereotypes, right? So I just took this off the internet this afternoon. This is probably not someone you would want to have dinner with tonight. Now, I might, because I think it'd be very interesting, but for most people, you have a stereotype about this individual. And you also have a stereotype about me, right? Because the dean gave me a very gracious introduction, and I came up here wearing a suit and all, but I'm going to take my suit off because I'm going to get comfortable. I'm going to take my shirt off. Now, had I come up to the podium in blue jeans and this t-shirt on, you would have had a very different view of me, I suspect. And I've noticed it. I live in a relatively small community, Sioux City, Iowa, it's about 85,000. And I wear blue jeans and t-shirts most of the time. And so I notice that I get treated differently when I go to stores or go to restaurants if I'm wearing a t-shirt and blue jeans or I'm wearing a suit. And I'm just an old white guy. Think about what it is for people in protected classes. So this is a woman. Her name is Lena Olive Smith. No one here would know her. I met her when I was 6 years old. My mother had passed away, and my father hired an African-American nanny. I considered her my second mother because I had many more years with her, and she raised me. And her best friend was Lena Olive Smith. And Lena Olive Smith was the first black African-American lawyer licensed in Minnesota. And she had been a hairdresser. And then she was a real estate agent. And she worked on the 7th floor of the Plymouth building in downtown Minneapolis, which is still there. And on the 8th floor was a night law school, the precursor to William Mitchell College of Law, where a Supreme Court justice went. And she enrolled in night school while she ran her real estate business, and she became a civil rights lawyer. And she was involved in the Scottsboro Boy cases and some of the Duluth lynching cases, and she was really the premier civil rights lawyer of her time. And she's the one that inspired me to go to law school and to become a civil rights lawyer. So I have a huge debt of gratitude. So I'm writing, I have short-term writing projects, and I have my decade-long writing project. My decade-long writing project, which is now moving into the second decade, is to write about the first minority lawyers in each of the 50 states. And so I started with Lena Olive Smith because I knew her. And when I was researching her background, I was in the Hennepin County Library. You all remember what microfiche is? I was going through some microfiche, and I found something that was absolutely astounding. It was a motion for new trial that Lena Olive Smith had filed in a case back in 1928 where she was representing a black man who had allegedly raped a white woman, and everybody in the courtroom was white except the defendant and Lena Olive Smith. And her client was convicted, and she filed the motion for new trial. And here's the thing that's so astounding. Everybody kind of thinks that implicit bias is a relatively new concept, and it is in the sense that social scientists haven't really got interested in the late 80s. And now, when I got interested in the early 2000s, you could actually read everything written about it. Now, there are so many articles coming out, mostly by cognitive psychologists, some by law professors and lawyers, that it's really hard to keep up because it's so much popular. But my point is, Lena Olive Smith understood implicit bias as well or better than I do. And here's what she wrote in her motion for new trial. So this was filed on June 18th, 1928. Motion for new trial, State of Minnesota versus Haywood, 4th District, which is Hennepin County. So here's what she said. The court, and it's really interesting the language that was used back in 1928. The court fully realizes, I am sure, that the very fact that the defendant was a colored boy and the prosecutrix a white woman, and the entire panel composed of white men, because in 1928, women weren't allowed to serve on juries in Minnesota. There was a delicate situation to begin with, and counsel for the state took advantage of this delicate situation. Perhaps the jurors were, with few exceptions, conscientious in their expression of no racial prejudice. Now, here's the amazing part, so I put it in yellow. Yet it is common knowledge, a feeling can be so dormant and subjected to one's subconsciousness that one is wholly ignorant of its existence. But if the proper stimulus is applied, and we're going to talk about that, that's now called priming, it comes to the front. And more often than not, one is deceived into believing that justice is speaking to him, when in fact it is prejudice blinding him to all justice and fairness. Isn't that amazing that in 1928, a trial lawyer had such a great depth of understanding of implicit bias? So, briefly talk about Project Implicit. Project Implicit is a website where you can take what's called an implicit association test. There are about 80 different tests now developed. You can test whether you have implicit biases with regard to race, sex, fat people, skinny people. There's a new one. It's not on Project Implicit, but it's about whether or not people have implicit bias against people who own pets. There's all kinds of tests that you can take. How many, just out of curiosity, have gone on Project Implicit and taken an IAT? Okay, yeah, well, that's great. So I encourage you to do it. I think one of the takeaways from this lecture tonight is go to Project Implicit, just plug it into your search engine of choice, and take 3 or 4. They take about 12 to 14 minutes. I would suggest race and gender first, but there are a lot of interesting ones, and take a few of them. And this is from their website. Implicit biases are pervasive. People are seldom aware of their implicit biases. I think unless you've taken an IAT, you're not really aware of any implicit biases. Implicit biases predict behavior. There's a big debate about that now. And so there's a growing kind of body. They're certainly in the minority, but very well qualified, I wouldn't call them eminent, but very well qualified law professors and cognitive psychologists who are criticizing the implicit association test. And I take those criticisms to heart, but here's the thing. Not one of the people who criticize whether the IAT is a good measure of implicit biases have ever suggested that we don't have implicit bias. They're just suggesting that the IAT may not be as accurate of a measurement tool. It has a lot to do with the algorithm they use and some other issues. So there is that debate. I think that's a healthy debate. And the three people who invented the IAT are refining it. They've got new algorithms, and they're trying to, make the best tests available. And other people will hopefully come up with other tests. So people differ in their level of implicit biases, and I've talked about the criticism. So I just want to share with you very quickly my experience with the IAT. I was about 12 years ago. I was teaching an employment discrimination class at Drake University with one of the law professors. We had taught it together for 20 years. And I was down in Des Moines. We were getting ready for our first class in early September, about 12 years ago. And he said, "Mark, have you ever taken an IAT?" And I said, "Russ, I don't know what you're talking about." He explained it to me. So that night when I got back home, I took the test, and I took the race test, and I had very strong anti-black implicit bias score. And I thought, well, that's odd. Before I became a federal judge, I was a civil rights lawyer. I told you about my experience with, I was so fond of, really she was my second mother, Tessie, and we were only the second law firm in Iowa racially integrated at the partner level. I was the hiring partner and the first person we hired after we started our law firm right out of law school with my two best friends was an African-American assistant U.S. attorney. He later became U.S. attorney a few months before I became a federal judge, and then I had the privilege of swearing him in a few years later as one of the few African-American state court judges. So most of my clients in my civil rights practice were African-American. So I was really shocked at my test results. So I took it later on, and then I waited and took it again, and I did, I think, what any trial lawyer or judge would do. When I kept getting this high implicit bias with regard to blacks, I assumed the test was invalid, and because it couldn't be me. So back then you could read everything about the IAT, in maybe a month or so. Maybe I read 60 articles, and I was convinced the test was valid. The problem wasn't with the test, the problem was with me, and that's when I got interested in doing something about it, which I'm going to close my presentation with all of the things I do in jury trials to try and reduce the effect of implicit bias, particularly with regard to minority defendants or minority litigants. So in order to understand implicit bias, you really have to understand some psychology principles, so we're going to go through some very quickly. Thinking Fast and Slow is actually the title of a book. Daniel Kahneman is a Nobel Prize winner. It's really a great book. It was on the New York Times bestseller list. And so this is just a diagram. You'll hear, it's become fairly common now to talk about System 1 and System 2, and that's what Daniel Kahneman kind of developed, and other people talk about it all the time. So I'll use myself as an example. I use System 1 all the time in trials. For example, I had a trial 2 weeks ago, a 2-week civil case. I guess it started 3 weeks ago. There are lots of objections. And one thing I learned, I think Judge Carr would agree with me, it's good to rule quickly on objections. You may be right or you may be wrong, but you rule quickly. You don't have time to get on Westlaw. You don't have time to send an instant message to your law clerk. You don't have law clerks sitting in the back of the courtroom with flashcards, overruled, sustained. I think that would be nice, but none of my law clerks ever want to do that. And the bottom line is they know a hell of a lot less about evidence than I do. I was really worried when I became a judge that I didn't know enough about evidence, and then I realized the only body that knows anything about evidence are the law professors. And it's really kind of a funny story. I had a very lengthy month-long trial, and I had a former law professor at the University of Iowa who was our federal public defender, and I had a brand new law clerk from Yale. And so this was a very complicated case. We had 12 defendants, and it was just unbelievably complicated, thousands and thousands of documents. And every time there was a tough evidentiary issue, I'd hear what the lawyers had to say it, then I'd say, well, Mr. Papek, what do you think? And Mr. Papek wasn't the one objecting. He didn't have a dog in the hunt, but he was the former evidence professor. So about 3 weeks into the trial, I was having a dinner with my law clerk, and she said, Judge, I'm just really curious. How come you keep asking Mr. Papek what he thinks when he's not the one making or defending the objection? And I looked at her and said, Colleen, he's the only one in the courtroom who knows anything about evidence. And then System 2, that's when we write opinions. We're thoughtful, we're careful, we can edit them, we have our law clerks help us, etc. So it is true that implicit bias is very ripe in the System 1 environment, but it also can creep into System 2. Just another example, System 1 is out front, System 2 is behind. So You know, we have explicit biases and we have implicit biases, and that's just a simple diagram to keep them straight. So we also have to understand in-group favoritism. And this is really an important concept and not something I really knew much about, even though I engaged in in-group favoritism all the time. And I'm embarrassed when I think back on decisions I've made totally on unrelated objective criteria, but based on in-group favoritism, which is the person is more like me than someone else. And it really came to head with law clerks. So when I would get an application from a law clerk, I was what they called well-traveled. I went to 5 different colleges and universities in 3.5 years. It's a long story, but it was actually the second lawsuit I ever filed, but that's a whole different story, pro se. But so when I get an application from a law clerk, and I see that they went to one of the colleges I went to that I didn't sue, I would say to myself, wow, that's great. You know, we have something in common. And, oh, they grew up in Minnesota, and I did too. That's great. They played high school and college tennis. Well, so did I. That's great. The problem is, none of those things have a damn thing to do with whether or not they're going to be a good law clerk or not. But I think we're hardwired in our DNA, and we engage in in-group favoritism all the time. And so until I became aware of it, and now I don't, or at least I'm recognizing when I'm leaning towards something based on in-group favoritism. So there are kind of the two dichotomies, in-group favoritism, out-group hostility. Some people, when it comes to race, have both. But the bottom line is, even if you have a high implicit bias score and you assume that it's valid with regard to race, and you have a strong anti-black implicit bias, it may be due to in-group favoritism, not any out-group hostility. And I say that because I think people don't want to be labeled a racist just because you have a strong implicit bias. So it's really important to understand and think about your own decisions that you make and how in-group favoritism. And the trend among cognitive psychologists is towards believing that in-group favoritism is responsible for more discrimination than out-group hostility. And they're actually refining some tests that are like an IAT that could determine whether your subconscious bias is a result more of in-group favoritism or out-group hostility. So that's kind of interesting. In-group favoritism, positive emotions like admiration, sympathy, and trust. Positive actions like hiring, promotion, more positive references. It's reserved for in-groups and withheld from out-groups, and it leads to bias and discrimination. So I want to talk about priming. Priming is really important. Our stereotypes are primed every single day, hundreds of times a day. So here's an example of a study that was done by Marizan Banaji, and they sold baseball cards on eBay. And they went out and gathered a bunch of valuable baseball cards, and they made sure that the cards were identical condition. And then they put them for sale on eBay. And what the cognitive psychologists or researchers would call the independent variable was the color of the skin of the hand. So they had identical baseball cards. If it was a black hand holding the baseball card, overall, they sold a bunch of baseball cards. Half of them had white hands, half of them had black hands. If it was a black hand, they sold for 20% less. And there's a similar eBay study involving gender stereotyping and implicit bias where they put mechanical tools related mostly to automobiles, so like car jacks and stuff to fix your carburetor, stuff I didn't understand. And so in the body of the eBay advertisement, they either indicated it was being sold by a male or a female. And when it was being sold by a female, the identical item on eBay sold for 20 or 25% less in terms of what people put a value on it. So that's an example of priming. Here's my favorite priming example. It is a study done by Harvard. They had 1,000 undergraduates, incoming freshmen, and they were sent an email allegedly from an upper-class student kind of welcoming to Harvard. And there were 3 different email addresses, and the students randomly received one of 3. So they either received Chen at wjh harvard.edu, which is the Asian prime, or Amy, same email address with the gender prime, or just the initials AC, which would be no identity prime. And in the first email that was sent to the 1,000 students, the person sending the email indicated that their own SAT score was 730 in quant and 720 in verbal. And then they had email exchanges going back and forth as part of the study, and they waited, it was either a week or 10 days, and then they asked the students, what do they remember about the initial email in terms of the SAT scores of the person who sent the email? If they got the Asian prime, the Chen, they remembered a quant score much higher than the 730. If they got the Amy, the gender prime, they remembered a quant score much lower than 730, but a verbal score much higher. If they had the no prime, the AC, they recalled much more accurately the test scores that were given. A great example of how something like an email address can actually prime stereotypes and implicit biases. So there's a good study I'm going to talk about at the end about how implicit bias or a prime can affect a juror's view of ambiguous evidence. And this was a study done by Justin Levinson at Hawaii. And the independent variable, and it's a complicated study, but the independent variable is one slide. They were actually showed 5 different slides. And you will notice that on the left-hand side, the skin is white, and through Photoshop, on the other side, is dark. And depending upon which photo they saw, dramatically affected how they interpreted ambiguous evidence. It's really a great study. But before to get to that, I want to talk about blind spot biases. So 2 of the founders of the inventors of the IIT, Dr. Banaji and Dr. Greenwald, wrote a book maybe 3 years ago or so called Blind Spot. It's kind of for the general public. They kind of translate all the cognitive psychology stuff, hidden biases of good people. It's a great read. So I'm really interested in blind spot bias. And Justice Kennedy last year, in a case called Williams versus Pennsylvania, he gave a great definition of blind spot. Bias is easy to attribute to others and difficult to discern in ourselves. And so there was a study done in 2010 of state court judges. It was done by Jeff Kuklinski at Cornell, who's on the law school faculty, but he also has a PhD in psychology. And he studies judicial and jury decision-making a lot. And he's got a group of people that he works with, and they do great work. And so he asked judges to rate their ability to avoid racial prejudice in decision-making compared to other judges in the room. I think they had about 130 judges in the room. 97% rated themselves in the top half. I'm not very good at math, but that's a little bit surprising. So I did a study of my colleagues last year, and I've done, I think, 4 or 5 now empirical studies of federal judges, and I tend to get a really good response rate. I asked them the same question, just so I put a little bit different twist on it. And so here are the results. I got a really, like I said, a really good response rate. So I broke it down between senior judges. My hypothesis was, and I don't know why, I mean, I had no basis for my hypothesis other than it's my hypothesis. The older you get, the greater your blind spot bias is. I don't know why I thought that. So I divided up between senior judges who tend to be older than active judges, although there's some overlap. You know, there's, I think, a district court judge somewhere in his 90s who never took senior status, but statistically, for the most part, senior judges are older. So it dropped down to 87% for federal district court judges. And then my hypothesis was that judges without life tenure in the federal system, which would be magistrate judges and bankruptcy judges, what we call Article I judges, they would have lesser blind spots. I didn't know why I thought that, but it turned out to be true. Statistically significant, magistrate judges and bankruptcy judges. And then at the last second, when I was doing this study, I thought, you know, I have access to 5,000 email address of United States probation officers. It would be interesting to see what their blind spot bias was. And my hypothesis was that it would be much lower than judges. And of course, probation officers are very important because they write pre-sentence reports that judges rely on. And some judges actually ask for a specific recommendation from the probation officer. Once I took my first IAT, I stopped taking recommendations from probation officers. I put a stop to it because I don't know what their implicit biases are. We have 27 different probation officers in our district, and I thought, it's my decision. I don't want to be influenced. And kind of interestingly, when I first started as a district court judge in '93, we have a very heavy criminal caseload. We're usually 6th in the nation number of criminal cases per judge. You'd think the Northern District of Iowa would be the sleepy little district. So I have a habit of always reading my pre-sentence reports at home. And sometimes I would have as many as 8 or 10 sentencings in a week. So my wife, who really has very little interest in what I do, but she's really interested in the sentences that I give. So she said, "What are you reading?" I'd say, "Well, it's a pre-sentence report." I kind of describe it. "Oh, you ought to give him probation. You ought to give her probation. Everybody ought to get probation," in my spouse's view. I said, "Well, there's a mandatory minimum of 10 years here, so we're not really talking about probation." But and then I realized, I don't want I love my wife. She's a lot smarter than I am, but I don't want her input because I don't know what her set of implicit biases are. And my law clerks, I never ask them. I say, if you want to read a pre-sentence report, read it, but we're not talking about it till after I impose the sentence. Nobody gives me any input on what I ought to do on sentencing. So probation officers, they had the highest, 96%, and I asked them to rank themselves in the top 25% of their respective colleagues in terms of their ability to make decisions. The first question was free from racial bias. The second question was free from sex bias. So the bottom line is human beings have huge blind spots. We see bias in others, but we're unable to admit or see it in ourselves. And that is the blind spot bias is a huge problem. So I want to try and combine some of the things we've talked about, priming and implicit white favoritism. So this is one of my favorite studies because it was subliminal. So what I mean by that is a third of the subjects either received the black face, the white face, or the squiggly lines. But they only saw it for about 0.23 milliseconds. So it's subliminal. So when it was flashed on the screen, if you were to ask them, "What did you see?" virtually no one would be able to tell you, "I saw a black face, I saw a white face, or I saw squiggly lines," because it happened like that. So the whole point is being primed subliminally dramatically affected the results of the study. So they were looking at what they called crime-relevant objects, like handcuffs, knives, guns. They picked what they thought was a crime-neutral, a relevant object. Now, I assume there are plenty of cases, probably they don't get to federal court, at least I've never heard or seen one, where somebody used an iron to kill somebody. But that's the difference between real world and sociological research, I guess, or cognitive psychologists. So they were asked to see when they could identify the object. So that's kind of what frame 1. It's actually a little fuzzier than that in the real study. By frame 20, you could kind of see it, and then by frame 40, it was obviously a gun. So then I'm just going to kind of post the results here and explain it to you. So what's important here is the white bar, and that's the one when they were a crime relevant object. So if they saw a flashing white face, they saw a flashing, let me go back, sorry. If they saw a flashing white face, it took them almost 28 frames before they could see the gun or the knife. With no face, just the squiggly lines, it was almost equal between crime relevant and crime relevant objects. But with flashing, when they were primed with the black face, they could make out the weapon in less than 20 frames. So just the fact that they were subliminally primed affected their ability to determine what they considered a crime relevant object. There's another study that reached the same results, almost identical, but what they were looking at were the ability to spot an ape image. So it was really fuzzy at first. If they were primed with this was an interesting study. Well, the other one is actually the same. It's got a reverse, when they were primed with whites, it took them a long time to see the ape image. When they were primed with a black face, they saw the ape image much more quickly. So implicit bias in children, this is a study by Dr. Banaji. Implicit biases are pretty well established by age 6. and they remain constant throughout life. They really don't change. Explicit biases do change. The older we get, the fewer explicit biases we have, so that's some good news. I just wanted to show you this video. I think all of the lawyers and law professors in the room remember Brown versus Board of Education, and you don't have to be a lawyer to know about Brown. And Thurgood Marshall argued that case in the Supreme Court. And one of the things he did in his brief, which was known as a Brandeis brief, is that he collected data from two clinical psychologists, Ken and Mamie Clark. Ken Clark was the first African-American psychologist to get a PhD from Columbia. His wife, I think, had a master's degree. And they did a study called Racial Identification and Preference in Negro Children. It's often called the DOLL, D-O-L-L study. They didn't have videotape at the time, so we can't see a videotape of their actual study, but they reported it. You can read about it. And Thurgood Marshall put that in his brief. And it was an important part of his argument. So I'm going to show you a study that kind of tries to replicate what Ken and Mamie Clark did.
Which doll is the black doll? And which one is the white doll?
That one.
Which doll is the pretty doll? Which doll is the nice doll? Which doll is the bad doll? Which doll is the nice doll? And which doll is the bad doll? And why is that doll pretty?
Because she's white and he has 2 eyes.
That's pretty troubling, isn't it? I want to talk to you just very quickly about neuroscience and implicit bias. So these are studies done in an MRI machine, and the only difference when you see the F MRI, it means functional MRI, and all it means is when you're in an MRI tube, the researchers are studying something. They're usually asking you questions, and then they're measuring your various parts of your brain. So the amygdala, and there are 3 parts of the brain that actually are involved in implicit bias, but I'm going to just talk about the amygdala and the dorsolateral prefrontal cortex. So the amygdala is, it's a Latin word for almond-shaped. We all have an amygdala, and it's our fear center. And it's channeled through various parts of the brain, but it winds up in the amygdala. And there are actually a few people on the planet who have had major brain surgery and had amygdalas removed. And one advantage or disadvantage is they have no fear of anything. You know, you could put them on the edge of the Grand Canyon, and they would have no fear whatsoever. I get within 10 feet of the Grand Canyon, and I'm shaking in my boots. And I'm screaming at my wife, "You're getting too close, you're getting too close, take a picture," you know. My amygdala is going crazy. So this is what amygdala activation looks like. And I'll just talk about, there's about a dozen, well, there are dozens of studies now where they looked at facial recognition. And what they do is they put somebody in an MRI tube, and they show them a picture of a white person and a picture of a black person. And they tried to make the faces not showing emotion, so they weren't glad, mad, happy, or sad. And they show black and white faces. And for Caucasians, the amygdala, not every person, but overall, there's strong amygdala activation when they see a black face, because black faces, in general, trigger a fear response in Caucasian people. And so they've also given IAT scores to people who have had their amygdala activated, and there's a strong correlation between IAT score on race and amygdala activation. So for the folks that are real critical of the IAT, it's pretty hard to explain a dozen studies like this that show the correlation. And there's no correlation with measures of express bias. And the darker the skin of the faces generate more amygdala activity. And so I'm going to talk very briefly about the dorsolateral prefrontal cortex. This is what it looks like when it's activated on an MRI. And here's the study. It's a very simple study. They brought in a group of kind of jury-eligible folks into a lab, and they brought them in, and they gave them a Stroop test. So I'll give you a Stroop test because it's real simple. So all you have to do is say the color of the word. The word. So let's do it. Red, yellow, blue, green, brown. Now you do it. Great. Okay. Give you a second test. No, it's red. Color of the ink. Yeah. Do this one. Yeah. No, you're not doing very well. You flunked the Stroop test. It's a very simple test, but it measures what's called executive functioning. And executive functioning is, I mean, we do it every moment of our life. When you pull into a parking spot and you see two yellow lines, your dorsolateral prefrontal cortex tells you that's where you park, so you know to pull in. You're hungry and you drive by a fast food place, your dorsolateral prefrontal cortex says you get food there, not at an auto parts store. So it's a very important part. So what they did in the study, they got the baseline of all the subjects. They took a Stroop test. Then they told them they're coming back in a week and they're going to have some more testing. They didn't say what. So the individuals all had appointment times. So somebody came in at 8:15 in the morning, and as soon as they came in and they sat down in this empty room with a bunch of chairs, a black man walked in who was well-dressed, just simply said hello, and sat down quite a distance from the person. And within seconds of that happening, they didn't allow any conversation. The researcher came out, they brought the person back in, and they took a Stroop test again. And shockingly, just that little interaction with a pleasantly dressed African American with no conversation other than hello or good morning, their Stroop test showed a rather dramatic decrease in their executive functioning. So just some social science research. Here's a study of physicians, because everybody has implicit biases. So this study looked at, it was the first IAT to study behavior of healthcare professionals. They used 220 internal emergency room residents in Atlanta and Boston. They gave them a clinical vignette, which included a description of Mr. Thompson, a 50-year-old. He reports with sharp stabbing pain. Half the doctors were told that he was African American, half were told in the vignette that he was white. Then they were asked, would you prescribe a thrombolytic clot-busting drug, which is very expensive? And then they were given a bunch of tests, and the tests were randomized. So they had measures of explicit biases, and then they took a race IAT. So the good news is doctors had no explicit bias, which you would expect that. The bad news is that the IAC scores were directly correlated with whether or not they gave the thrombolytic drug. So the higher anti-black IAT test score, the less likely they were to prescribe thrombolytic drugs. This is a study of who ideal litigators are. It was done by Professor Jerry Kong. It looks like King, but it's Kong at UCLA. And so it's a priming example too. So he had two actual depositions. So you could see the person being deposed, and you could hear the lawyer asking the questions, but you couldn't see who the lawyer was. So they were primed with either it was an Asian American male or a Caucasian male. That was the prime. They watched the deposition, and then they were asked how good the lawyer was in taking the deposition and whether or not they would recommend that lawyer to a friend. And the bottom line was, well, I can just tell you the bottom line. Well, here we go. Both explicit and implicit stereotypes of ideal litigators as more white than Asian predicted more favorable evaluations of the white litigator over the Asian litigator. Here's one on, it doesn't involve an IAT, but it's really interesting. for lawyers. It's a black-white legal writing skills study. So they took 22 large national law firms, 60 partners. There's the demographic background. And they were told they were evaluating a memorandum from a third-year associate who graduated from NYU Law School named Thomas Meyer. Half the partners were told that he was black, and half were told that he was white. The hypothetical memo, they deliberately inserted errors in the memo, a lot of errors. And then they had the partners review the memo, and the results, I don't know if you can all see this, but I just picked out some of the results. Here's an example of, on the subjective part, a generally good writer but needs to work on, has potential, good analytical skills. That was if they were told he was white. If they were told he was black, the partner said, need lots of work. Can't believe he went to NYU, average at best. And then, when they were told that he was black, they found many more of the errors than when they were told he was white. That's pretty staggering. There's no correlation between the race and ethnicity or sex of the viewing partners. I just added this as an aside. Female partners found more errors and wrote longer narratives, which is one of the reasons why it's a gender bias, but my female law clerks are really much better at editing my drafts than the male law clerks. So the overall ratings of Caucasian received a 4.1 out of a scale of 5. The African American 3.2, very statistically significant. So I just decided to throw in sports. There's only one study I know of, and this is really interesting. It's an NBA study, and they looked at 10 years of games, and they used a very sophisticated multiple regression analysis, and they were trying to look at whether or not the racial makeup of the reffing crew, they used 3 people to ref NBA games, whether the racial makeup affected the number of fouls that were called. I'm not much of an NBA fan, but I have a sleep disorder. I have a hard time going to sleep, so if I'm channel surfing, there's a minute left in the game, I'll watch that, because a lot of times it comes down to, you know, the last shot. Not always, but a lot of the games are pretty close. And they determined that the racial makeup of the game, of the refereeing crew, had a huge impact on the outcome of the game. And the NBA has spent a ton of money trying to discredit that. Don't have time to talk about Tudor Biostudies, so we're just going to talk about one jury study. Well, we'll talk about 2. Misremembering facts. So I like to pick on Brian Williams. So this is a study that Justin Levinson in Hawaii did, and he gave jury-eligible participants, they read a civil case and a criminal case, very short scenarios. One was about a fist fight that involved a minor assault criminal charge, and one was about an employee who were terminated. The independent variable, of course, was the race of the protagonist. The fight story, they were told William was a Caucasian, or Tyrone was an African American. Employment story, Brenda Caucasian, Keisha an African American. Participants misremembered certain legally relevant and important facts in a racially biased manner. Participants who read about Tyrone recalled 80.2% of aggressive facts, but if they read about William the Caucasian, only 68.2%. And participants falsely remembered that Brenda being employee of the month 17% of the time, and Keisha only 16% of the time. There was nothing in the scenario that indicated anybody was employee of the month. They just simply misremembered things, and that happens a lot. So this occurs in ways that are completely unknown to the fact finder, but prejudicial to the legal actor. So one more study, it happens to be a Justin Levinson study, and it's the one I showed you at the very beginning. Subjects reviewed 5 crime scene photos of an armed robbery at a quick stop mini mark. The only difference was one photo showed the forearm of the robber, half saw light skin, half saw dark skin. Then they were told 20 pieces of ambiguous evidence. So the best example, there are 2 pieces of ambiguous evidence that I really think held the tale. They were told that when the person was arrested for this crime, they found a stub for a movie in their pocket, and that the police looked at it, and it was for a movie theater that was quite a distance from where the armed robbery occurred, and the time of the show made it impossible for him to be in the movie and also rob the Cook Mini Mart. If they were primed with the black skin, here's how they rationalized that. He bought the movie ticket to create an alibi and put it in his pocket. If they were primed with the white skin, he's not guilty. Now, there were some discrepancies, but that's generally the results. And that was true with many of the pieces of ambiguous evidence. And then Justin did something really interesting. He decided to ask them, how guilty is this defendant with 20 pieces of ambiguous evidence? So he just created the 0 to 100, 0 being not guilty, 100 being guilty, and all the participants had to rate, if they found the defendant guilty, how guilty he was. And of course, there was a dramatic difference in how guilty the defendant was if they were primed with the one photo of the black skin. Significant, and then he gave them IATs, significant correlation between black and guilty, and white and not guilty in IAT, and warm feelings towards black actually increased the implicit bias score, which is interesting. So I'm going to talk about judge studies. There's only 2 studies out there that have given implicit association tests to judges. The first one was done by Jeff Kuklinski and his team in 2009. And it's a complicated study. And they were all state court judges in 3 different parts of the country, mostly juvenile court judges, and they gave them a number of scenarios and then looked at whether or not the judges found that the juvenile was delinquent or not, and then what the punishment would be. So strong white preference among white judges, who all of whom took the IAT, mixed preference among black judges comparable IAT scores to blacks on the internet. So there are millions of people now who have taken the IAT at Project Implicit. If you're Caucasian, about 85% have a moderate to strong anti-black implicit bias. If you're black, it breaks down about a third, a third, a third. A third of blacks have no bias, a third have a pro-white bias, and a third have a pro-black bias. And white judges had statistically greater IAT anti-black feelings than the average person who takes the test at Project Implicit. So this is a study that I did along with Justin Levinson, and our statistician was Yoichi Hayoki, who's a Japanese college professor, teaches statistics there, and he helped us out with the study. And we did a white-collar fraud scenario, and our independent variables were Asian and Jewish, and we picked them because they're considered privileged minorities, and nobody's really studied it much in terms of implicit association. So it was a hard study to do because we wanted to do state judges and federal judges. So I took a pre-sentence report that I had done in a white-collar case and used the same fact pattern. It was a pretty sophisticated fraud scheme. And so we had to change the pre-sentence report so that state court judges, because they're not used to federal guidelines, and some states have their own guidelines, some don't. So I created a pre-sentence report. We used focus groups of federal judges, focus group of state court judges to help refine it so that everybody could understand it. And then I used a random state generator. I didn't know one existed, but I just Googled random state generator. Sure enough, there's a bunch of them. They ask you how many states you want, and bingo, you get a printout of states at random. I picked 15 arbitrarily, got 15 states, wrote the Chief Justice of the Supreme Court of every state, and asked permission to study their trial court judges who do felony cases because we were doing a study on sentencing. I didn't want to tell them it was an implicit association test because I didn't want the judges to know. So we did it. We got a good response rate. We wound up actually doing 8 of the 15 states for reasons, technical reasons, and we had federal judges respond from every circuit. And so the results are pretty interesting. If I can get to the next slide. Judges are implicitly biased against Asians. Federal and state court judges strong to moderate implicit bias against Asians relative to Caucasians. Asians were associated with negative moral stereotypes, greedy, dishonest, scheming. Caucasians were associated with positive moral stereotypes. We did a bunch of explicit measures of bias as well as an implicit association test, and they were randomly mixed up, so you either get the express questions first, the implicit bias, the IET test second, or vice versa. Jews, same thing. They had the identical kind of stereotypes and negative moral stereotypes about Jews as they had with regard to Asians. All judge cohorts possess similarly strong implicit biases, whether they were state court judges, appointed judges, or elected judges, or whether they were federal judges. All of the judges as a group had stronger implicit bias against Asian and Jews than what the general public has based on Project Implicit data. Federal district court judges gave longer sentences to Jewish defendants, although it was marginally significant, and that was probably my fault in terms of the design. I figured out afterwards we should have done something a little bit different, but we did show a marginal significance. Male judges showed a stronger anti-Jewish implicit bias than female judges. This was good news. Political party of the appointing president did not predict IAT scores or the length of sentence. Protestant and Catholic judges had higher pro-Christian, anti-Jewish IAT biases compared to judges who reported no religion. Judges' self-reported agreement with Asian stereotypes were correlated with their agreement with Jewish stereotypes. Anti-Jewish pro-Christian implicit biases predicted the sentencing length of Christian defendants. The higher the bias, the shorter the sentence. So I want to talk briefly about Afrocentric facial feature bias. This is what I'm talking about. The individual on the right has very strong Afrocentric facial features. The individual on the left, not so much. There have been 4 studies done in 4 different states looking at the sentencing and then looking at the arrest photographs of defendants and then using very sophisticated regression analysis. And the bottom line is the stronger the Afrocentric facial feature, the longer the sentence. And the darker the skin tone, the longer the sentence. That's true in every study. Here's something that's really interesting. About 2% of Caucasians have strong Afrocentric facial features. We don't really think about that. I mean, I've never thought about that. And, let me add, on the Afrocentric facial features, cognitive psychologists and sociologists use 9 facial features, and it's real easy. So there have been studies done about how the general public, how easy they are to identify Afrocentric facial features. And so if I had 9 photographs going from the most Afrocentric facial, the strongest Afrocentric facial features to the lightest, I shuffled them up randomly. I gave them to everybody in the room and said, you put them in rank order from either the least to the most or vice versa. 94% of you would be 100% accurate in doing it. So it's not that hard. But if you're a white defendant with strong Afrocentric features, watch out. You actually get a longer sentence than black defendants with Afrocentric facial features. We'll figure that one out. I've got a new law review article coming out in January. I did with a law professor and cognitive psychologist at Berkeley, Victoria Plout. And we didn't do any empirical work, but we analyzed the 4 empirical studies on Afrocentric facial features and skin tone. And then we did extensive research tracing back the Afrocentric facial feature and skin tone bias back to the Civil War. And we looked at Civil War literature, post-Civil War. We looked at medical stuff. We looked at literature. We looked at a lot of different variables and then came up with the conclusion that if you have strong Afrocentric facial features, not only do you not benefit from a presumption of innocence, but people presume you to be guilty. And that's been verified in a study by Jennifer Eberhardt at Stanford. Just look at the top box. This is a study of 600 death penalty cases in Philadelphia. Can you imagine one city having 600 death penalty cases? And so the black bar represents strong Afrocentric facial features. It's not really an issue on black crime in terms of who gets the death penalty, but if it's a white victim and you have stronger Afrocentric facial features, you're twice as likely to get the death penalty. So I want to talk just very quickly about my approach to the presumption of innocence and implicit bias, and I've written about this. And here's the problem. I've been at this for 23 years. We have a lot of criminal trials. 55% of the defendants that we try are minorities. I can count the number of times in over 200 criminal jury trials that I've had a minority juror. I can count that on one hand. Matter of fact, I can count it on two fingers that I could recognize as a racial minority, and they were both Hispanic. So that's a huge problem. And so I want to talk first about the burden of proof. This is a chart that I use, and I actually showed the potential jurors in jury selection, and I go through it with them, and we talk about, well, if you've heard all the evidence and you think I kind of go up the chart, he's perhaps guilty, you suspect he's guilty, possibly guilty, probably guilty, guilt likely, guilt highly likely, that's not enough. So I want to get them to visually understand the burden. And then when we get to the presumption, it is not enough to mouth a few platitudes about the presumption of innocence. It is not enough to show the prospective jurors my jury instruction on the presumption of innocence with what I do, because they don't get it. And every single study that's been done on presumption of innocence instruction concludes that jurors don't understand it. So the lawyers and the judges, we have a lot of work to do. And this is being sarcastic, which I am. You could tattoo the instruction on each of the jurors' forehead. So they went back to deliberate. They still won't give the defendant the benefit of the presumption of innocence. So here's what I do. I learned this when I was a law student by watching the premier criminal defense lawyer in Des Moines, Henry T. McKnight, who happened to be African American. He asked this great question of potential jurors. He'd have his clients stand up, and then he'd just pick on a potential juror, and he'd say, "What do you think? Is my client not guilty or guilty?" And the juror, I watched him in 3 trials, and the potential jurors always said, "Well, I don't know. I haven't heard any of the evidence." So I've been asking that question in every criminal trial I had as a lawyer, and in every criminal trial I had as a judge. And 99.9% of the time, even after I showed them the presumption of innocence instruction, I'll say to a potential juror, I'll have the defendant stand up. "Mr. Rodriguez, would you please stand up?" I'll say to a juror, "You've just heard the instruction on the presumption of innocence. What do you think? Is Mr. Rodriguez not guilty or guilty?" 99.9% of the time, the answer is, "I don't know. I haven't heard the evidence yet." They do not understand the presumption of innocence. There's only one acceptable answer. The defendant is absolutely not guilty unless and until the prosecution proves guilt beyond a reasonable doubt. So I've been frustrated for years by why, when I explain the instruction, do I still get this result? I don't know. So about 7 years ago, I happened to be trying Mr. Rodriguez, and I went through 7, 8 jurors. They all said the same thing. And I'm pretty spontaneous, like, putting on this shirt. So I stood up from the bench. I didn't know I was going to do it. It just kind of came to me. Kind of dangerous, but I like to live on the edge. There's always a court of appeals. So I stood up. I walked off the bench, and I walked over to the defendant. Nobody in the courtroom knew what I was doing, including me. And I reached out my hand and put 2 hands on him. I said, "Mr. Rodriguez, it's a pleasure to meet you." And then I turned to the 31 prospective jurors. I was standing, they were a foot away from me. And I looked at every one of them, and they were wondering, what is happening? I took a look at the assistant United States attorney. His jaw was on the table. He didn't know whether he should object or what to do. And I looked at these potential jurors, and I said, "I just shook hands with somebody who's absolutely not guilty." Then I paused, and I said it again. "I just shook hands with somebody who's absolutely not guilty, unless or until the prosecution can prove him guilty beyond a reasonable doubt." And then I played the role of a flight attendant, and I said, "See the 2 exits on each side of the courtroom? If you can't give the defendant the full benefit of the presumption of innocence, please stand up and walk out the door, because you're not serving on this jury." And I've had people do that. And I always applaud them. That's what I do. And I say, "Thank you very much. You've served the United States just as well as the jurors are going to serve, because you honestly, for whatever reason, and I'm not here to judge you, you can't give the defendant the presumption of innocence." So my time's up, but I'll show you maybe I'll show you 2 videos. I'd like to show videos to prospective jurors. So here's a video that I used to introduce implicit bias. And I stop it right here, but I won't here. So I'll tell you what happens when I stop it. Get the punchline? So when I stop it after murder, then I ask the potential jurors, what do you think about the person pictured in the video? He's terrible. He should have been given the death penalty after the rape. How could he have gotten out and murdered somebody? And I let them just vent. Then I'll say, next juror, what do you think? What do you think? What do you think? I've been doing this for probably close to 10 years. Once this year, I had a prospective juror say, well, how do we know the guy in the video is related to that rap sheet? Only one person. And then when I let them vent about how terrible he is, and then I hit my button, play the rest of the video, and they find out he's the arresting officer. And then I tell them, you know, when I saw it, I fell for it hook, line, and sinker. I just assumed it was the defendant. Well, why do we do that? And then that leads into a discussion of implicit bias. And I'll just show you one more video. It comes from a TV show called, maybe many of you have seen it, What Would You Do? It's an ABC show hosted by John Quinones. It's called The Stolen Bike Scenario. So I'll just play a teeny bit of it.
You see this and you wonder, did he lose his keys or is he blatantly stealing that bike? In broad daylight, he hammers and then saws on the chain. When that doesn't work, he pulls out an industrial-sized bolt cutter.
Okay,
and when
that's the first part of the video. The second part of the video is the same scenario. Notice that it's a public park and they're just walking by. Second part is an African-American male about the same age as the white guy. And then they pan into the park and they see person after person whipping out their cell phone and dialing. Presumably they're dialing 911 because they think he's stealing the bike. And then the third scenario is really fun. They show a very attractive, young, blonde Caucasian. And she's, you know, hammering away with the saw. And then they show the males who are often paired with a female partner. You don't know if it's brother, sister, husband, wife, boyfriend, girlfriend, you don't know. They are peeling away from their female partner, driving up to her, and she's saying, oh, I've always wanted a bike like this. And the males jump off their bike. They don't go for the saw. They immediately go for the bolt cutters, and they start cutting the chain. And then so after I play those three scenarios, I have a discussion with the jurors. Why is it that people reacted so differently in these three scenarios? And it's really a great way to start a discussion about implicit bias. I'm just going to close with the jury instruction that I give. This is actually a juror pledge. At the end of jury selection, I have them take this pledge. You can't read it, but this is a $250,000 poster. And I have it on each wall of the jury deliberation room. Now, you're wondering, why did it cost $250,000? Very simple explanation. My daughter went to a small private liberal arts school, and she was an art major, and she designed the poster for me. So basically what we talk about in jury selection is not to let gut feelings, prejudice, stereotypes, personal likes or dislikes, sympathies or generalizations affect their judgment. This is what my actual jury instruction looks like. And then they get it again. It's a little bit more, as we discussed in jury selection, everybody, including me, has feelings, assumptions, perceptions, fears, and stereotypes. That is implicit biases that we may not be aware of. These hidden thoughts can impact what we see and hear, how we remember what we see and hear, and how we make important decisions. Because you are making very important decisions in this case, I strongly encourage you to evaluate the evidence carefully and to resist jumping to conclusions based on personal likes or dislikes. And then I also tell the jurors that it is their duty, when they go back to the jury deliberation room, that if another juror brings up what you think is a stereotype or a bias, you have a duty to call them out on it. And I expect you to do that. And that's part of your constitutional obligation as a juror. And it's very important that you do that. And this is just the last thing. I don't have a call-out box, but this used to be required in federal death penalty cases. And it says, by signing below, each juror certifies that consideration of the race, color, religious beliefs, national origin, or sex of the defendant was not involved in reaching his or her individual decision, and that the individual juror would not have returned the same verdict for or against the defendant. So I showed this certification to the potential jurors, and then I showed them the verdict form with their signature. And I asked them to sign that they understand the certification and that they will not make a decision based on these protected classes. And I have found over the years that when they know they have to sign this, it's really amazing they're responsive. I had a trial earlier this year with a Hispanic defendant. It was fine, talked about implicit bias. Some people got up and walked out. That was great. But when I showed them the certification, I said, now, is everybody comfortable? If you get selected to serve, are you comfortable signing the certification? I had a gentleman raise his hand. I'll never forget what he said. He said, Judge, my mother would turn over in her grave, but I have some feelings about Hispanics. I'm not sure I could sign the certification. I said, thank you very much. You serve the United States as well or better than the 13 jurors who would be selected to serve. Glad to have you back on another case, and send him on his way. So that's kind of my spiel. I'm way over time, so I apologize for that. Thank you very much.
Okay, so now questions for Judge Bennett?
Yes.
It's amazing. You mentioned the privileged minorities, Asians and Jews, and it reminds me of a situation in the mid-1980s of Judge Charles Kaufman, who was a Jew in Detroit that had been held in an internment camp in Japan during World War II. And the reason his case made national news was because back in the 80s, there were 3 white gentlemen that assaulted with a baseball bat an Asian. And Judge Kaufman gave them probation. And it made national news. Do you recall that case?
I don't recall it, actually.
Well, then forget it. It was pointed out that he was being racially biased against people of Japanese descent.
The Asian victim. Yeah. I guess nobody knows but him, and maybe he doesn't know. Right? Right. Yes. Dan?
So if our bias is implicit and we don't consciously know it's there, I'm just wondering how the kind of explicit, the jury instructions are explicit. Does that work? Does that help me to ignore a bias that I'm not even aware of in myself?
That's a great question. And I do a lot of empirical stuff. I don't know if it works or not. And so maybe I just feel better doing it, and that may be the only value. There is one study, actually. There's a really pretty solid empirical study done by a woman named Paula Hannaford Agar at the National Center for State Courts, and they used my instruction in the study, a little bit different version of it, which I don't think is as good as mine. And they found that it had no effect. And she's a good friend of mine, and I think it's a really good study. I was relieved that it didn't have a negative effect, because that's a possibility. And when I originally designed the instruction, I consulted about 6 implicit bias scholars, including 2 of the 3 that invented the IAT, and that was their primary concern. Would it have a negative effect? And so we worked on the language for a long time, and they think it doesn't have a negative effect. So the study was good in the fact that it doesn't do any harm. That should be just like physicians do no harm. My criticism of the study is that, yeah, maybe just giving the instruction by itself doesn't do any good, but I have a very lengthy discussion with jurors about it. And we talk about it in a lot of different ways, and they see the videos. And so does all of that make a difference? I don't know, but when judges criticize my instruction, they say, well, there's no empirical evidence that it works. Here's my response. There's no empirical evidence that any of the instructions you've ever used in any of your trials or any judge has used in the history of the United States work. And actually, if you want to talk about your presumption of innocence instruction, all of the data shows that it doesn't work. So you can criticize my instruction all you want, and I get that. I welcome the criticism, but, you know, where's the empirical evidence your stuff works? And why aren't you trying to do more when all the empirical evidence shows that a presumption of innocence instruction doesn't work? Why do you just give the instruction and, you know, pray for the best? Because the evidence is it doesn't work. So that's kind of my response. Yes?
Any translation to any rise in not guilty verdicts since you started doing that instruction?
Yeah, the answer is no with regard to the instruction. With regard to the handshake that I do with the defendant, I'm doing an empirical study of that. So they either get the scale of 0 to 100. They either get it before the handshake or after the handshake. It's randomly selected for each trial. So I'm trying to just focus in on what the handshake does. And there's fairly strong evidence that after the handshake, they have a much greater appreciation for the presumption of innocence. And they find that as the defendant sits there, they're much more willing to give them the full benefit of the presumption of innocence. My goal is not to get more not guilty verdicts. And so when people ask that, you know, I don't study that because that's not my goal. The bottom line, my goal is to make sure a defendant gets the fairest trial. And in our district, it sounds bad, but most of our jury trials, they're not really trials. They're slow guilty pleas. They're 4-day slow guilty pleas. Defendant has no defense. The evidence is overwhelming. There's all kinds of corroborating evidence. And the defendant is going to trial because they're going to get hit with the big mandatory minimum, and they have nothing to lose by rolling the dice. I'd go to trial too if I were in this situation. That's why I never begrudge a defendant going to trial. But so I don't think the measure is, does it increase not guilty verdicts? But that's a good point. I don't know. Yes?
Similar studies on who's offered a decent plea bargain versus not offered a plea bargain?
Yeah, there are some studies on plea bargaining, and they're not. There's nobody that's done a plea bargaining with IAT tests for prosecutors, but the studies indicate that Caucasian defendants get better plea deals. That's pretty universally accepted in terms of the social science research on it. Yeah, and at all the pinch points in the criminal justice system, arrest, bail, whether you get it or not, the amount of the bail. Certainly with regard to Afrocentric facial features and darker skin tone, there's evidence that every single one of those pinch points, it adversely affects an offender, an alleged offender, if they have darker skin and greater Afrocentric facial features. I'm doing a study, well, I'm designing a study now, and then I'll close with this. I'm looking at whether or not Afrocentric facial features and darker skin tone affects the believability of an alibi witness. It's really a pretty easy study to design. And then on the civil side, I'm looking at whether or not darker skin tone and greater Afrocentric facial features reduces the amount that jurors would award in emotional distress damage. And I'm still in the design process. I mean, I don't have it. You have to have pretty sophisticated morphine software on the faces, and so I'm a long ways from rolling that out, but I'm working on it. Great. Thank you all very much. Thanks for coming.